SJC-11929, Commonwealth v. Angelo Teixeira, and SJC-11944, Commonwealth v. Christopher A. Meade.
Good morning, Mr. Palmer.
Good morning. May it please the court, my name is Valerie De Palma. I represent the defendants Angelo Teixeira and Christopher Meade, and with me today is trial counsel for Angelo Teixeira, Jeffrey Miller. This case is about power, the power of the district courts to order discovery before a probable cause hearing in cases over which they lack final jurisdiction.
Could I just ask you this question? Is this a Suffolk problem in your view, or is this happening all over the Commonwealth?
From what I understand from talking to the counsel for CPCS and amicus, it appears to be a problem in Suffolk rather than other counties, but it's a significant problem here in Suffolk County.
What does that mean? You mean other counties?
Other
Judges are
counties-
simply ordering discovery,
Or
these-
just providing it.
Or indictments happen faster, or what?
According to him, defense counsel is just receiving discovery at district court arraignments
Well, of course,
without an order.
there's still an investigation going on, presumably, in these cases, because the grand jury is either meeting or is about to meet. So what kind of discovery are we talking about?
He
Just
didn't go
police
into
report?
he didn't go into detail, so I don't want to misspeak, but my sense is discovery that's available to the Commonwealth. He called it a packet. They receive a packet
So
at
it's
district court
kind of
arraignment.
the packet that you get on arraignment in the Superior Court? Is that-
Yes, and
is that your sense?
I'm
Yeah,
only,
yeah,
I'm
go on. In this case, was there any, when Mr. Teixeira and Mr. Meade were arraigned in the Boston Municipal Court, is there any information that comes, there is some at arraignment, isn't there?
The
Some
police
discovery?
reports.
The police
the
reports.
police reports. In both cases, there were police reports, but in Mr. Teixeira's case, the reports referred to the witnesses as persons known to the Commonwealth, as well as there was an off-duty police officer who also wasn't identified by name.
Were the reports redacted, or was that the way they were written?
No, that was the way they were written. It's in the Commonwealth's record appendix in this case. It says known to the Commonwealth.
So is the practical problem here that you don't get the information, you can't contact the witnesses, the probable cause hearing does not go forward in the district court because everybody's waiting for the indictment to come down, the indictment finally comes down, and then you're in Superior Court?
Yes, that's the practical reality as the amicus.
So you don't get the hearing in the district court?
And you don't get to start investigating your case. In Teixeira's case, he got some of the discovery 63 days later when the arraignment occurred, but he didn't get everything until 111 days later, which is about based on CPCS's data regarding arraignment to arraignment waiting period.
63 days was arraignment in the Superior Court?
He was, but he
Okay.
didn't get, he did not receive two of the addresses of two of the percipient witnesses. And in fact, the Commonwealth had by that time filed its brief in this case, and counsel read it and said, I didn't get those addresses. And then at the next date, as I understand it, he got everything, but that was already 111 days. So for 111 days, counsel couldn't do anything, basically. I mean, he didn't have anything. He had an investigator. He had an allowed motions for funds. He couldn't send him out to start interviewing witnesses and conducting their own independent investigation of the facts, which is a core function recognized by this court and in all the rules of.
Am I right, though, that you don't have a right to a probable cause hearing unless you waive indictment?
No, you don't ever have a right to a probable cause hearing, really.
Well,
What does the statute say about that?
it says that it's under, I mean, I believe in Perkins, the rule was that the defendants do have the right in murder cases to a probable cause hearing.
Yeah, unless there's an indictment.
Right, exactly. I mean, only once an indictment occurs does the issue become moot.
Right.
Yes. But this is the problem, is the Commonwealth can moot, you know, the timing of indictments is entirely within the Commonwealth's timeline.
So what is the order? I mean, of course, you'd like us to affirm Judge Poole's and Judge Grant's order here, but what's the standard? There is no rule which provides for it, so it would have to be by motion of the defendant. Agreed?
Agreed. I think that the defendant has to establish good cause, and in fact, when I was looking at Perkins, that's the standard for the Commonwealth in seeking a continuance beyond 30 days is good cause. And the court should balance the interests of the parties, the defendant's need for the discovery, his inability to get it through any other source, and of course, in the Teixeira case, it was, you know, without the names of the witnesses, there's very little that counsel can do on
And the Commonwealth's need to make
protect
sure
those
that,
witnesses' identity, but I would submit that, you know, the discovery is how, what implements the right to counsel. I mean, counsel, that core function cannot be discharged without meaningful, or at least, you know, discovery that is available at that time. There's just, they're essentially having to wait around. And while the Commonwealth certainly has interest in protecting its witnesses, there's also a mechanism for doing that, which is called a protective order, which the court, both judges ordered in these cases, and they were.
yeah, but, I mean, I think there is some value to the Commonwealth's point that even with a protective order, if you're, particularly in Suffolk County, if you're talking about witnesses who are going to be reluctant to start with, and then they get a call from the defense counsel who wants to interview them with an investigator, it has its, you know, that could be a concern to the Commonwealth. I'm not saying it's should win in every case, but it's a legitimate concern that people are not going to want to testify.
But I see your point, Your Honor, but I think that, well, you know, defense counsel is an officer of the court, and
No,
they
it has
are,
nothing to do with, I'm assuming absolute good faith, but it's just the fact of you're starting with somebody who doesn't want to be a witness anyway. So it's just the way it is. I mean,
true, Your Honor, but they also make a choice. I mean, they make a choice to proceed in the district court, and that
Right.
course of conduct, you know,
They make a choice, they may have to make an arrest,
yeah.
pending further investigation. I mean, sometimes it's a matter of you've made an arrest, now you've got to bring some charges to hold them, and, you know, attempted murder, whatever it may be. But that doesn't mean the investigation is somehow over.
No, not at all.
All the witnesses have been identified, located, brought in, put under oath. That doesn't mean any of that.
No, not at all. However, but the defendants, as amicus again points out, are detained. They are detained
Right.
for the most part.
Right, and there's a
pending
bail hearing.
this-
Yeah, I understand that. There are bail hearings, right?
Right, but then,
Yeah.
after that occurs, there's just,
And there's been probable cause of some sort to justify the issuance of the complaint.
true,
Okay.
to
So
arrest.
are you suggesting there's somehow a constitutional right to get pre-indictment discovery?
I think to the extent it's necessary to receive the effective assistance of counsel. I think it's tied to that.
The
Right.
effective assistance of, it's getting discovery as early as possible is necessary to satisfy the effective assistance of counsel requirements?
Well, as this court has recognized, a prompt, independent, factual investigation is paramount
Yeah,
to
but-
that
That may be the defendant's obligation, and the fact that the defense counsel can't quite get all the details from the Commonwealth because the investigation is still continuing, you're suggesting that means the Commonwealth is violating the Constitution.
Well, I mean, in the Teixeira case, they didn't get anything. I mean, counsel had what was in the court's file, basically.
Right.
I mean, it was minimal discovery. And I think that concern has to be factored into this.
As I recall, in the federal system, witness statements don't even have to be turned over until just about the time of trial.
I believe there's a local rule, at least in Massachusetts. I cited to my brief.
But I'm wondering, how could that be constitutional? You don't even get the statements of the witnesses until close to trial.
Well, I think, under the federal system, there's no...
Different constitution? You're saying this is...
Well, no, I'm saying that if there's no constitutional right to a probable cause hearing, but if there is a statute that provides the right, the person has to receive the effective assistance of counsel. There can be no laws or rules that interfere with the provision of that right.
Well, is your argument more directed towards what you need to do with respect to the probable cause hearing, or, just to take the amicus brief, is it more that you've got this constitutional obligation, well, the defendant has the right to effective assistance, and therefore the obligation is, you're assuming that there's not going to be a probable cause hearing, because generally there is not. A relic of the past, to use a quote. And so is your concern the probable cause hearing, or is your concern a larger one of effective assistance of counsel with respect to these facts and being able to investigate?
I think I thought of it as my briefs for the defendants in this case sort of assume that, or proceed on the theory that probable cause hearings actually happen.
Okay.
And that the discovery
Is necessary for
is
that.
necessary to litigate that question. The amicus brief filed by CPCS proceeds on the assumption that they don't happen, and that because of that reality, a rule permitting counsel to receive discovery is necessary to correct the injustice of defendants being detained 3.5 to 4 months between arraignments, and that they're being, they're detained, they're hindered in their ability to assist in their defense because they can't consult with their lawyers as freely as someone who isn't detained. And for these reasons, so there's sort of what in theory is supposed to happen if probable cause hearings were conducted as they were, I understand some years ago, and how it's happening now, at least in Suffolk County.
If it were a constitutional obligation, it would be there regardless of whether the defense attorney asked for it, would it not?
Yes, that's true, and I think that part of what I'm here to persuade the court is that the district court must have this power. They must have the power to order discovery to ensure that justice is fairly...
And that's, I guess, that's what I'm asking for. I mean, is it not sufficient to say that a district court judge has the authority in the interest of justice to do this, as opposed to saying that it is constitutionally required for a district court judge to do this?
I think it's required. The district court judge is required to ensure justice, and part of that function is to implement or issue orders that ensure the defendant has access to those rights.
But if it's a balancing test, I mean, there is a difference between pre-indictment and post-indictment in that the Commonwealth, especially in various murder cases or shooting cases, want to put individuals before the grand jury and lock them into sworn testimony so that if they subsequently recant at trial, they can use that testimony substantively against the defendant. So there is a difference between pre-indictment and post-indictment. may the judge not consider that difference in deciding whether it's appropriate?
I think they should, but they should also consider that those witnesses don't belong to the Commonwealth pre-indictment. In other words, by not providing counsel with the names and contact information of the witnesses, counsel has no opportunity to examine them, has no opportunity to see maybe they have, maybe their statements may be of assistance to the defendant, and that the Commonwealth has sort of a monopoly at this point on these witnesses who theoretically are supposed to be available to both parties. I see that my time is up, but in sum, I would like to say that this court should rule that the district courts have authority to order discovery before probable cause hearings. The orders of the judges in both Teixeira and Meade were a proper exercise of its discretion. And this court should order dismissal of the indictments in Teixeira, given the Commonwealth's flagrant disregard of Justice Poole's discovery order. Their conduct was an effrontery to him, an obstruction of the criminal process, and a waste of judicial resources. Thank you.
Good morning, Ms. Leary.
Good morning. May it please the court. Catherine Leary on behalf of the Commonwealth. Under Massachusetts law, by statute, and by rule, there is no right to discovery in advance of a probable cause hearing. It's a purely statutory right, the purpose of which is to provide an additional check against the government and to put the Commonwealth to its task of ensuring that the charges are warranted and that there's no unmeritorious prosecution.
Well, let me stop you. I mean, under federal law, Justice Cordy made reference to the Jenks Act. I think I remember it's 18 U.S.C. Section 3500, if that's my memory. That said that the Commonwealth could not be required under law to provide it, but judges all the time, and in fact, I guess recent local rules say that the attorney must. Even if there's no statutory or rule obligation, doesn't a judge have the authority in the interest of justice to say this is what I think is most appropriate?
District courts are courts of limited jurisdiction, and where the legislature, and they derive their rights from the powers to act from the legislature, and where the legislature created the right to a probable cause hearing and did not include the right to pre-hearing discovery, I think the court is limited and without authority.
Are there statutes that allow the right to discovery in a superior court, as opposed to rules?
Your Honor, I believe it's just.
I mean, do we have? Is it only because the legislature? Are you saying that because the legislature hasn't addressed this issue, it doesn't that there is no power? That's your argument, is that right?
That is part of my argument, that the rule, the statute just does not provide the right to discovery because the legislature crafted this statute within the existing framework that there would be an ongoing grand jury investigation often in these cases where probable cause hearings do occur.
So if we were to craft a rule which would provide for this discovery, you would say that that rule is in violation of a statutory prohibition?
I would say that the proper avenue of this court were to craft a rule would be to convene a rules committee and get an input from all the different stakeholders and members of the bar, such as prosecutors, defense attorneys, judges, rather than basing it off of these two cases and these two factual scenarios.
Okay, but that's not my question. I understand that, but the better process may be to do all that. But if that rules committee were to come and if this court were to embrace that rule, would you be coming before us and say that is illegal because the statute prohibits doing just that?
Your Honor, I believe just district courts and the superior court or the court's limited jurisdiction, this court is mandated by the Constitution. I'm not fully prepared to answer that question. I'm sorry, Your Honor. And as the court has noted, there are sound policy reasons for why there's no pre-hearing discovery. Especially in Suffolk County, there's a very big concern about witness intimidation and ensuring that witnesses will be willing to come to the grand jury. There's concern about possible taint of evidence, not that I would suggest any bad faith on the part of my brother or sisters, However, suggesting a different course, questioning a witness before they can lock in their testimony about how they remember their events could lead to...
So do you think that the Commonwealth has a monopoly on witnesses prior to the grand jury?
No, Your Honor, I don't, but I do think there
So
is...
if an independent investigation by the defendant were able to locate these witnesses, they're not allowed to talk with them? Because it might interfere with the Commonwealth's ability to put them before the grand jury in an untainted way?
No, Your Honor, I believe there's value to having the Commonwealth conduct an unfettered grand jury investigation. The Commonwealth does have a legal and ethical obligation to conduct a fair grand jury hearing, and the goal is not to give the Commonwealth an advantage and to poach witnesses. It's purely to ensure that witnesses are willing to come forward and help with
But
the
isn't
investigatory
that
nature.
something that a district court judge or a BMC judge is able to weigh? I mean, if the standard that Ms. De Palma is arguing for is good cause. So, you know, she says what she says, the ADA says what she says, and the judge makes a judgment about whether good cause has been shown or not. I mean, that's different than saying there is absolutely no authority to do it. Maybe in your case, your argument could be there was an abuse of discretion, but that's different than saying it's not legally possible for the judge to do, which is, I think, your argument.
That it is my argument that under the statute and rules, the judge has no authority to issue discovery.
So if this happens in other courts, could you comment on counsel's response to Justice Botsford's question about whether or not this is a Suffolk issue versus what goes on in other counties?
Your Honor, I can't comment on what happens in other counties. If there is discovery being handed over in other counties, I believe it's at the discretion of the prosecutor in those counties, but I can only speak to what happens in Suffolk County.
So you think it's a purely discretionary tool within the prosecutor's sole control, and not something that the courts in any, that the district courts, the BMC has the authority to order?
Yes, because under statute and rule, there is no discretionary authority under Section 38 or Rule 3F for the district court to order this discovery. And I think that the defense attorney is well equipped at these hearings if we act under the assumption that these hearings are going to be occurring, that the defense attorney has the complaint, has the police report, albeit in the Teixeira matter, the witnesses' names were not included. But when you look at what it means to test probable cause at a probable cause hearing, defense attorney can test on the percipient witness's ability to observe, vantage points, ability to recollect, their motivations for testifying.
Can't the defendant put in his own evidence?
He can.
Yes, and how can he do that if he doesn't know who the witnesses are said to be?
He can put in his own evidence because he knows the factual nature of the charges.
Of the charges.
Of the charges and the events of how they're described in the police report. He has the time, place, location. So if the defendant has, for example, an alibi defense, he would be able to put that forward. I think that it's important to remember that the probable cause hearing is placing the burden on the Commonwealth to produce the evidence. And it's the Commonwealth's burden that they have to meet it. And
So is the Commonwealth under any obligation to move with all deliberate speed to have a probable cause hearing within less than 110 days, or whatever it was in this case?
I think the Commonwealth is always under an obligation to proceed with swiftly with the indictment process.
Statute, I forget what it is, but the statute says it has to, doesn't it say, within a certain amount of time?
As soon as reasonably possible. And in Commonwealth v. Perkins, the Commonwealth does have a duty to proceed swiftly as possible.
And does the rule have a date?
The rule does not have a date, is my understanding, my recollection of reading the rule. And I think the facts of these, I think it's important to look at the facts of these cases and the concerns of the Commonwealth are not frivolous, especially in the Teixeira matter. In open court, the defendant engaged in witness intimidation by gesturing with his hands as if they were guns and threatening to shoot two Boston police detectives.
So should we make a decision on this rule based on the peculiar facts of that case?
No, Your Honor, I just think
There be another way of handling that kind of situation?
of where witness intimidation.
When a defendant does what you say he did in this case. I mean, not every defendant is going to be in that situation where they're being accused of witness intimidation. Probably most aren't.
That's correct, Your Honor. I feel like this case it is illustrative of the concerns we have. However, it's also concerning that this happened in a court and the district court judge still ordered the discovery on this matter.
And challenge that on the basis of an abuse of discretion.
No, Your Honor, we did not.
So can you help me understand, what is it about the statute that prohibits a judge from ordering discovery? I don't see anything. You're talking about 276, Section 38, are you?
Yes.
Okay. What is it in the statute that prohibits a judge from ordering discovery?
Well, you're correct that the statute does not explicitly bar a district court judge from ordering discovery. I think that you cannot read words into a statute that aren't there, and that when the legislature crafted the statute and provided the right for counsel to cross-examine, to present evidence, and to argue against a showing of probable cause, that they did not include the right to discovery because they did so within the existing framework that an ongoing grand jury investigation would be happening in these cases. And I think that where under Commonwealth v. Clerk Magistrate, you can't add words just to a statute that the legislature did not include. And I think it's reasonable to think that the legislature did not intend to add a right to discovery in advance of these hearings.
I mean, I guess the concern I have is if you had a if you had an eyewitness case and your police officer waited 3 or 4 months before he or she interviewed that witness, I assume as the ADA you'd be unhappy with that officer because she would say the memory of the events have faded and it's going to be, to wait that long is irresponsible because you're losing the fresh memory of the events from that individual. But that's what you're requiring the defense investigator to do.
That's correct, but I feel that the concerns about having a fresh record of what happened from the witness's point of view is those concerns are alleviated by the grand jury by having a witness testify in the grand jury. The defense counsel will get the grand jury minutes at, I believe, Superior Court arraignment, and so he's able to, how a witness remembers the events are locked in.
Except if the witness is not helpful to the Commonwealth, perhaps they don't put that person before the grand jury.
The Commonwealth does have a duty to present exculpatory material to the grand jury and to have a full investigation. I would also argue that the grand jury is not merely an accusatory body, it's also an informing body, and so it's in the interest of the Commonwealth as well to ensure that we have a complete, full investigation to ensure that the charges are warranted. And I would also argue that sanctions would not be appropriate in the Teixeira matter, as the Commonwealth was pursuing its appellate remedies by filing a 211-3 petition with a single justice. And for all the reasons stated in my brief, I don't believe that the district court, under Massachusetts law, under the rules or statute, has authority to enter this discovery.
One last question. Judge Poole, I know, issued a protective order. Did Judge Grant do that as well? I couldn't see from the record.
She did, Your Honor, and it was about giving the victim's name or witnesses' names and information to the defendant.
And if we were to find that the discovery order were appropriate, do you have any quarrel with the protective orders that were issued in this case in terms of their protectiveness?
Only so much as to the fact that I don't think the protective order alleviates the Commonwealth's concerns of intimidating witnesses based on just the fact that a defense attorney or their investigator is coming to speak to them, or possibly tainting testimony before a witness goes into the grand jury.
Both of these cases are moot, correct?
That's correct, Your Honor.
All right, thank you.
Obviously, a grand jury is convened really under the supervision of the Superior Court, isn't that right?
That's correct, Your Honor.
And if there are issues of compelling witnesses to come before the grand jury or getting further tests from witnesses, that's all decided in the Superior Court, right?
I believe, Your Honor, but I'm
Yes.
not sure. I don't know the answer to that
It
question.
is.
All right.
Okay, thank you.
So I'm just curious, are there any cases in which defense counsel has actually gone to the Superior Court and said, my client is the subject of a grand jury investigation and I would like to get some discovery so I can do my investigation?
Your Honor, I
Never heard
don't,
of that.
I've never heard of that. I don't think that a defense attorney has a right to pre-indictment discovery or to discover the case before it's indicted.
Okay, thank you.
Thank you.
Thank you. And we'll take our morning break.